How can I avoid probate and protect my family?
Whereas in other states, probate may not be as time-consuming or expensive, in Florida, it makes economic sense to take steps to avoid it. First, we have to be clear what probate is and what probate is not. Probate is not a tax. Probate is the process under which your last will is admitted to court, your personal representative, who you may know this as your executor, is appointed, accountings are filed, taxes are paid, and ultimately your beneficiaries receive their inheritance. This court process is avoided through the use of revocable living trusts. When we have clients who may benefit from revocable living trust planning, we take them through our unique estate planning process that we call the Family Estate and Legacy Solution, which is designed to transform your legal, tax, and financial concerns into a coordinated and understandable estate plan. When you schedule your initial appointment with us, we're going to send you a client organizer. That initial appointment with us is complimentary provided you do three things. We want you to complete that organizer in full. We want you to gather your current estate planning documents, and we want you to watch another DVD that describes the Family Estate and Legacy Solution in greater detail. We ask that you drop off your completed organizer and your estate planning documents with us prior to the first meeting. That way we can hit the ground running.
During our initial client conference, we're going to focus on your goals. What is most important to you? Is it protecting the inheritance you leave to your loved ones? Are taxes a primary concern? What about having proper health care directives and living wills? We'll address all of your goals and concerns, which will lead us to developing a plan that's right for you.
Next, we're going to engage in the Family Estate and Legacy Solutions responsibility conversation. This is actually a lot more than who's going to be responsible for distributing your estate at your death. What about your disability, for example? Well, first off, how are we going to even determine that you're disabled? Many physicians won't sign a disability statement for fear of liability, so we need to put some provisions in your trust that deal with your disability. Along with that, who's going to be responsible for managing your investments, or writing your checks, or dealing with your CPA to file your tax return? There are many variables and many different situations that apply depending upon your individual circumstance, and we're going to figure out what's right for you and your family.
We'll create your custom design plan based on the criteria that are most important to you. We have different plans that minimize estate and income taxes, that provide protection for your surviving spouse, and that can even protect the inheritance you leave to your children and grandchildren from the claims of predators, creditors, or divorcing spouses. We'll also quote you a fixed fee for your plan. We do this as we want you to be involved during the planning process. If you have a question, we encourage you to call us. There will never be any extra charge for your calls or questions during the planning process.
During the document knowledge builder step, we're going to go to the drawing board and prepare your trust, pour-over will, durable powers of attorney, healthcare surrogate, living will, and other ancillary documents that are important to your estate plan. You're going to receive easy-to-read and understand summaries and flowcharts of your plan. In fact, we're going to sit with you and review your plan in great detail so that you completely understand the plan and make sure that it's consistent with your intent. Once you've signed your documents, you're going to receive your estate planning portfolio in a neatly organized and tabbed personalized binder.
Even though you've signed your documents, we're not done yet. At your direction, we'll send digital copies to your CPA and financial advisors so they'll understand your plan and be able to assist you from their end. We've often reviewed documents with our clients' other advisors to make sure that all of your advisors are on the same page. This goes hand in hand with our family estate and legacy funding process.
Often folks who've drawn up revocable trusts nevertheless don't avoid the probate process. Now, why is that? Typically it's because they have not funded their trust. During our funding process, we help you retitle your assets into your trust so that they'll avoid the probate process on your passing. Now, we help retitle things like your money market accounts, your certificates of deposit, brokerage accounts, even your real property. Now, many people wrongfully assume that once they've retitled their assets into their trust that they'll lose control over those assets. But that's not the case. You retain full control over the assets during your lifetime, as you often are the trustee of your trust and you have the power to amend and revoke your trust at any time.
And to make sure that your plan remains current and right for your situation, we enroll you in our Family Estate and Legacy Maintenance Program. Your estate plan is something that should be kept up to date, and this program is an easy and cost-effective way to do just that. In fact, your first year in the program is free once you've signed your documents. We'll send you a written review of your trust each year. If the tax laws or trust laws change, we'll update your trust for you. You'll also have the opportunity to make changes to your trust to keep up with your family and financial situation. In addition, we hold special educational workshops exclusively for our maintenance clients and their invited guests. Whether you can attend the workshop or not, we often forward a DVD of the workshop, so you'll be able to watch it at your convenience.
Thank you for joining us. We hope that this Florida residency and estate planning video helped you understand the various issues that you'll be facing as a new Florida resident. Mike Hill and I are both board certified by the Florida Bar in Wills, Trust and Estates. That means we've met the highest criteria under the bar. Our firm was originally established back in 1924, and we have vast experience helping people just like you. Moreover, our firm is rated AV by Martindale-Hubbell, the highest attainable by the National Independent Attorney Rating Service. So let's get started. Please call 239-334-1141, or you can call toll-free 866-386-4439. You'll schedule your complimentary first appointment with us, and we'll send you your introductory client package. Thank you for spending your valuable time with us. We hope to visit with you soon.